The Premier of Saskatchewan, Scott Moe, there defending his decision to use the notwithstanding clause to override the Charter of Rights and Freedoms and keep a pronoun policy he recently announced in force. Now, the notwithstanding clause allows provinces to temporarily override people's charter rights. On Thursday, a judge in Regina issued an injunction against that policy, which would require students under the age of 16 to get their parents' consent prior to being able to change their names or pronouns at school. The judge saying the policy would do, quote, irreparable harm to at-risk students, such as transgender students. Well, the federal Justice Minister Arif Virani joins me now. Mr. Virani, thank you for taking the time for us here on CTV. Much appreciated.
Thank you for having me.
What do you make of Premier Moe's promise to use the notwithstanding clause in this case?
Well, I'll tell you, Todd, I reflected on it as a parent of two children myself, one of whom is entering those teenage years. I reflected on it as obviously the Justice Minister. And I guess the first thing I would say is that no one wants to be demonizing communities or groups in this country or pitting people against each other. But I'll say to you that on reflecting on it, I know as a lawyer what it takes to get an injunction. It's sort of a temporary measure that stops something from taking place, and it's a pretty hard test. I've had to argue cases like that in court. You have to demonstrate that there's a serious issue at stake. You have to demonstrate also what's called irreparable harm, that if it goes forward, the harm caused would be irreversible. That test was met, and a judge in Saskatchewan recognized that on Thursday, and that's significant because it's pretty rare. But then the second thing that's supposed to happen is that there's supposed to then be a full hearing about the issues that were raised at a later date, and where you can get an airing out of whether the charter has been breached or not, etc. And what I'm troubled by is that by indicating that the Saskatchewan legislature is going to invoke the notwithstanding clause, you're sort of short-circuiting that entire process, and you're cutting off that dialogue. And when you say, it's an override clause, that's because that's what it is. You're doing something that will override the charter rights of individuals, including in this case, potentially very vulnerable children. And that gives me pause. And I think that should give any government pause about slowing down. And instead, what we see is a government sort of wanting to press fast forward. And it's not the orientation of our government. We've always said, the Prime Minister said, I have said, that the notwithstanding clause should be used as something of last resort, not as sort of the first volley in what's supposed to be a dialogue. It's meant to be the final word, not the initial statement shouldn't be the last statement in that dialogue.
The Premier has indicated, Mr. Virani, that he's going to recall the legislature early in order to use the notwithstanding clause. I know that the legal counsel of Your Pride, You Are Pride, which is the University of Regina's Gay Pride Center, they've called the use of this frankly shocking. You talked about demonizing people, and you're saying it's giving you cause for pause. What does that mean, though? What might you be able to do about this?
Well, at this stage, the legislature has not been reconvened. The legislation has not been proclaimed. The notwithstanding clause has not been used. I'm just taking my cues from what Premier Moe has indicated he wants to do. And what I would also say is that it's troubling insofar as when we think about the charter, we think about the protection of minorities and vulnerable communities. And when we deal with the LGBTQ2 community, the subset of people who are children, who are perhaps struggling with identity issues, who don't feel comfortable about how to raise those conversations, where to raise them, and feel that their security might be at play, that's a very small subset of individuals. I think what we need to be seeing is that we need to be listening to the concerns of those people, and at the same time listening to the concerns of parents like me right around the country that fairly say that we want to have a role in how we raise our kids and sort of those parental sort of roles that we all seek as people that are raising children. Those are equally fair views to be heard, but we're not hearing any of that because we're not listening when we invoke such a blunt instrument like the notwithstanding clause and short circuit that dialogue that happens between parents and children, in this case, sometimes school teachers. Because what Premier Moe is suggesting that he will do is that he will invoke a notwithstanding clause that just short circuits the discussion. And that is what I find troubling in terms of sort of being a preemptive use of something that should really be a tool that's used as a tool of last resort.
The Premier has said that a majority of people in Saskatchewan support the move to make sure parents are informed and give consent to schools prior. But I'm curious, you just talked about it there, whether there's something your government can do, Mr. Virani, to make sure the rights of trans students in Saskatchewan are protected.
I think what we do as a government in Ottawa is what we do every day, and what I do as the Attorney General, someone who's sworn an oath to uphold the Constitution, is I always am attentive to the need to defend minority rights wherever they occur around the country. And what I'd say to Premier Moe or anyone else who's watching is that my answer on this issue would be exactly the same if we were talking about an issue of racial discrimination or gender discrimination or religious rights. It's really important that we stand up as elected leaders in particular in defense of minority interests. That's what the Charter is meant to do. That's what it's been doing since its invocation in 1982. And that's something that I will stand by and defend.
I know that your government has long championed LGBTQ rights and prides itself, that it's made a priority of that over the last 8 years or so in power. Let me ask you, how far would you, as the Justice Minister, be willing to go over this issue in Saskatchewan?
Well, I think it's a bit speculative in terms of how far this will go because, again, we don't have legislation that's been invoked. I think you can take your cues from what you've heard by the Prime Minister himself in terms of the importance of defending the rights of vulnerable communities around the country. And what I'd like to see, and I don't mean to sound cliche or metaphorical here, but to my mind, the vision of Canada, particularly since the Charter was invoked, is about different groups coming together and standing up for one another, right? It's about a situation where you have non-racialized people standing up against white supremacists. It's about a situation where you have men speaking out against misogyny. It can't be just a vulnerable community that's expected to carry the torch in defense of its own cause. I think we need to all rally together. And I'm speaking to you, Todd, as a racialized Muslim man myself. There's a lot of division right now in Canada, and sometimes when we sow that division, it can lead to intolerance and hatred and even violence. And that's something we all need to stand against. And that starts with listening to parents, listening to kids that are questioning how they feel or what role or how they feel that they belong. That's a listening exercise that needs to take place. A premature invocation of the notwithstanding clause short circuits that listening exercise. And we need to be doing that listening. And that's what I'm concerned about.
If Saskatchewan decides to push ahead, Mr. Virani, is there anything that the federal government can actually do? I mean, I know other governments, other provinces have used the notwithstanding clause in the past over controversial issues. The issue of language in Quebec comes to mind many times in that province. Is there anything that Ottawa can actually do if it is invoked?
Well, I'll say what we've already said with respect to some of the litigation in other parts of the province is that if these questions get to the point where they're getting to the highest court in the land, the Supreme Court of Canada, what we've indicated is that we will be there as an intervener on behalf of the Government of Canada, on behalf of with respect to protecting minority rights under the Charter and speaking to the usage of the notwithstanding clause.
All right, on a separate issue, while we have you here, let me ask you, the Polish government has said it wants to extradite Jaroslav Hunka from Canada. As you know, he's the Ukrainian-Canadian war veteran who fought for a Nazi unit during World War II, recently honored accidentally in the House of Commons. Big embarrassment for Canada. Question, if you were to get an extradition request from Poland, would the government support that?
So let me just first start by talking about what happened in the last sort of 7 days in Parliament. Deeply embarrassing, deeply troubling for all Holocaust survivors, particularly the Jewish community. I'm very pleased that Anthony Rota took responsibility for what had transpired and made the difficult decision to step down. In terms of an extradition matter, Todd, my hands are tied in terms of discussing extradition, and I want to explain to you why. I'm the ultimate decision maker in an extradition request. It is a sensitive, confidential matter of state-to-state relations. It goes through various processes that are set out in statute. As the ultimate decision maker, I can't compromise my ability to render an objective decision by opining about the existence of a request or what I think about the merits of a request. So I politely and respectfully, I cannot answer that question.
Bigger picture, let me ask you about whether you think it's time for Canada, so to speak, to come clean on the issue of possible war criminals. You know, back in 1986, a commission, Deschênes Commission, looked into this issue. The report has never been fully released, including the names of approximately 240 alleged Nazi war criminals who may, Mr. Virani, have been living in Canada. Would you support the full release of the Deschênes report, as some leading Jewish groups are now demanding that Canada do?
And I understand the request and the concerns of those Jewish groups. I believe CJA has been quite public about this request. And what I would say is that Canada's history and legacy with respect to Nazis in this country is a difficult one. It's a troubling one. And this matter needs to be addressed along with so many other issues that relate to anti-Semitism as exists in this country. What I'd say to you with respect to the Deschênes Commission report is that all options are on the table in terms of how to move forward in a manner that respects the wishes of the Jewish community and people that want more transparency about this issue.
Arif Virani is Canada's Justice Minister. Mr. Virani, thank you so much for taking time for Power Play today. Much appreciated.